God, of the United States, and this honorable court. This honorable court is now in session. Please be seated and come to order. Good morning, everyone, and welcome to the District of Columbia Court of Appeals. We're first going to hear the consolidated cases known generally as Office of People's Counsel versus the Public Service Commission, 16 AA 815, 817, and 825. Let me just say generally, the court has studied the briefs very carefully. We've studied the record. Time is limited, so I will ask counsel to get right to their main points. I'm going to do the best I can to enforce the time limits we have established. I understand that the Office of People's Counsel will be arguing first. Mr. Strauss.
Good morning. May it please the court, Scott Strauss for the Office of People's Counsel, and I would ask to reserve 2 minutes for rebuttal. Your Honors, OPC is here today because the process the Commission used to decide this important proceeding was unfair to District of Columbia ratepayers. Without providing adequate notice or a fair opportunity to be heard, the Commission changed course and decided to consider Exelon's unilateral request for merger approval, and then in the same order granted it summarily. The Commission knows this process is inadequate because it's contrary to how the Commission dealt with the filing of the parties' non-unanimous settlement agreement in this case. The Commission responded to that submission by reopening the record for the sole and limited purpose of considering the settlement, and then adopted a procedural schedule that allowed the parties to make a record on that settlement.
Counsel, when I read the applicant's motion for other relief, it's fairly clear to me that they're asking for a ruling in their favor on the merits. Why wasn't that enough notice so that you could gear up to oppose it?
Your Honor, for a couple of reasons. First of all, because the process that the Commission had established, the record was closed to anything but settlement relief. It was reopened for that sole and limited purpose. The Commission was extremely clear about that.
But why does that? I'm not sure why that bears on notice if it's clear enough that the applicants were asking the Commission to rethink that and to, instead of focusing on the limited matters that had previously been what the Commission was willing to focus on, grant them relief on the merits. If that's clear enough, why does the prior approach that the Commission had been taking bear on the adequacy of the notice that the Commission was being asked to do something different?
Let's consider the context at the time, Your Honor. The application, the original application, had been rejected on the merits. The settlement that the parties had come up with, which the Commission reopened the record only to consider that settlement, had been rejected. The revised settlement that the Commission had created had been rejected. So at that point, under the Commission's regulations, and the Commission made this clear in Order 18109, the only thing that was before them appropriately was joint relief, requests for joint relief by the settling parties, who could either have accepted the terms or, if they'd rejected the terms, jointly asked for some kind of other relief. Otherwise, the choice under the rules was to proceed with the litigation. What we had here, what Exelon effectively did in their unilateral motion, was essentially make an offer of settlement. And offers of settlement are not permissible under the Commission's rules, and there's a very good reason why. In the way in which the Commission's regulations work, Section Rule 130.16 makes clear that when the Commission is faced with a non-severable settlement agreement, it has the option of affirming it, confirming it, or rejecting it. If it rejects it, then under 130.17, it has the chance to offer the settling parties alternative terms. But it does not have the authority under the rule to compel the settling parties to accept those terms.
Fair enough, but I'm a little unsure. You're saying two things that seem a little bit different. One is whether an offer of settlement is permitted. That is to say, a party can come in and say, I would be willing to settle on the following terms. Are you saying a party's not allowed to indicate that willingness, and the Commission is not allowed to even be aware that that is one thing that one of the parties is willing to do? Or
If,
are you saying something different, just to finish the question? Sorry, let me just finish the question.
I'm sorry,
Let me finish the question.
apologize.
Thank you. Are you saying that, or are you saying instead that the commission can't take that and say, here is the ground on which we are disposing the case, this is an offer of settlement, and that's a kind of disposition of the case?
The commission cannot dispose of the case on the basis of an offer of settlement. Had the commission wanted to consider this as a motion for summary judgment, then we say what they should have done was gone through the analysis they did when they considered the non-unanimous settlement after the record had closed. They would have reopened the record and established a process to receive evidence on this new motion for summary judgment.
Did you say any of this in your opposition to the motion?
Yes, Your Honor. In the joint appendix, I believe it begins at page 1340, the office made clear that this pleading that that Exelon had filed was procedurally out of bounds.
And a lot of your argument seems to depend on characterizing it as a unilateral offer of settlement. Your opponents have a different characterization.
Yes, Your Honor.
Suppose we say it's a proposal for a ruling on the merits, which is within the commission's authority.
Of course, Your Honor. Let's be clear. We're not saying the commission could never get there. But process matters greatly, especially in a proceeding of such magnitude. And in this instance, if the commission wished to go in that direction, to recharacterize this, what was presented as a Rule 130.17b filing in the title, was never characterized as a Rule 105.8 motion for summary judgment. If the commission wished to go in that direction, then it owed the parties to go through the analysis of saying, we're going to reopen the record, we're going to consider this on the merits, and we're going to set up a process so that other parties can have their fair say. That's consistent with this court's decision in the embassy case that we cite in our reply brief, I believe at page 8. It's also consistent with the Supreme Court's Celotex case. If the court or the agency is going to move to a summary judgment process, they have to give the parties notice that that's where they're going.
Can I ask
here
you,
we didn't have
relative to notice, I guess another way of looking at it is whether your client gave the commission adequate notice that among the objections it had to the request for other relief was not just it's out of bounds for some of the reasons you've been describing, but that although there has been a lot of process already, there have been lots of hearings and lots of things, and the litigation seems to, on certain issues, to be narrowing. One of the concerns is even on the issues that remain, there is a need for additional process. We need to have evidence. We need to have discovery. We need to have a hearing. And the question is, where did you give notice to the commission that that was necessary?
What we were faced with after Order 18109 and the revised terms in the unilateral offer, we believed at that point was a question of whether that was properly in front of the commission. And given what we knew at the time, as I said, that the original application had been rejected, the settlement and the revised settlements had been rejected, our understanding was at that point, based on what the commission had said, that the record was closed to unilateral relief. Under the rule, if the settlement fails under Rule 130.17, the next step is to proceed with the litigation. In this case, that would have meant the application had been rejected, it had never been amended, and applications for reconsideration were pending. So what OPC informed the commission of at that point in its March 11th filing was to reject the request for unilateral relief and expeditiously conclude the litigation, which would have meant proceeding with dealing with the application for reconsideration. When we learned in Order 18148 that the commission, in fact, was prepared to both consider and grant the relief at the same time, without any additional process, we did, in our application for reconsideration, explain to the commission that additional process was needed if they were going to change the rules and move in that direction.
Which of the conditions that the commission ultimately imposed as, in its view, necessary to make a determination that this application was in the public interest, do you oppose?
There are several.
Or is this an argument strictly for turning the clock back to do the procedures correctly?
It is an argument to turn back the clock and do the procedures correctly, but there are substantive concerns we would raise if we had those additional procedural rights, and I can explain what those are. The specific provision...
Very briefly, but I just want to be sure there's something substantive at issue here.
Absolutely, Your Honor, absolutely. There are three key provisions at issue. One is the $25.6 million residential rate credit, which was a guarantee under the settlement and a core reason OPC signed it. The guarantee has been eliminated. The second one is a period of rate repose, no rate increases until March 2019. That has been eliminated. The third one was the so-called incremental offset provision. And the way that was going to work was, if PEPCO sought and got approval for a rate increase before March of 2019, it would keep those dollars in sort of an escrow account, or what's called a regulatory asset, and begin to recover them after March of 2019, but only at $1 million a year. Terribly important because that would minimize rate shock on consumers who would then be subject to these increases. So these were vital to OPC.
You have no ability to make any of these contentions in the present rate proceeding before the Commission?
We can make certain of these contentions, Your Honor, but the reality is the reason that OPC settled was because it had a guarantee of these protections. If they had not been guaranteed, if it was simply a right to argue about them later, the People's Counsel would not have joined in the settlement. That was the whole purpose for us.
Mr. Strauss, you're down to a minute. You can
Reserve
reserve
my
it or
time for
continue.
rebuttal.
Thank you.
Thank you, Your Honor.
Next up is DC Sun and Public Citizen. Mr. Arkush.
Thank you, and I'd also like to reserve 2 minutes of my time, or whatever I have left when we're done. I wanted to start actually just by answering the first couple of questions that the court asked of OPC. The question was, why wasn't the fact that that Exelon made clear it was asking for, made clear what it was asking for, why wasn't that sufficient to give the parties notice? I think at the end of our reply brief, if you look, we gave 7 reasons why in the context at the time that was not sufficient. And those were, the agency had already rejected the settlement twice. It had a condition precedent to approving the RNSA, which was that the settling parties had to accept it, and they had rejected it. The Commission had said it wouldn't shore up proposals on its own. It's different to offer the settling parties an opportunity to shore up the proposal, but the settling parties had rejected that opportunity. The Commission itself had recognized that the record had key gaps on important issues in the NSA, which it tried to resolve in the RNSA, but still suffered from the same record problems. The agency acknowledged openly that it hadn't even contemplated that the kind of relief that Exelon was asking for was possible, which is another reason not to grant it on the merits without further process. The parties only had 10 days to respond to Exelon's request, which presented 3 different sets of terms to evaluate and argue about.
Did you ask for more time to respond?
No, we believed that no more time was necessary. We believed that the agency would not consider the request on the merits, that they should reject it out of hand as procedurally inappropriate, and that if the agency
Why shouldn't we conclude that you predicted and lost? That is, your expectation of what would happen turned out to be wrong.
Because in the context of this proceeding, there is absolutely no reason why the parties would have expected the agency to actually just grant Exelon's request without any further notice.
Are you aware of a case that supports the idea that if a party asks for relief and the opposing party responds by opposing it on one ground and doesn't address the need for other process if the court was actually going to consider that kind of relief, that the failure can be excused on the theory that the opposing party reasonably predicted that the motion would be denied on some other ground? Are you aware of authority that would point us to the idea that that's a...
I'm certainly aware of authority as a general matter in agency notice cases. For example, in the rulemaking context, another party's contention is not notice of what the agency itself might do. That's clear in the rulemaking context. I haven't seen it in the adjudication context. I also haven't seen any case that has remotely similar facts. Right? This was already an extraordinary proceeding that the agency had reopened, waiving its own rules, reopened to consider a specific settlement agreement, and then that was already sort of a...
In a way, that seems to cut against your point. If the commission had already, there'd been a big process, and you kind of thought the thing was over, and then all of a sudden the commission is doing some further things that didn't seem like what would ordinarily be the case, and then a party is saying, let's keep going. You said you were only going to go so far on this path, but we'd like you to go further. It seems to me that what you're characterizing as already extraordinary steps by the commission should have made it more foreseeable to you, your client, rather than less, that the request for relief might actually have been granted, and if that you needed further process before that merits decision was made, you needed to ask for it.
Your Honor, I think it cuts the other way, because when the agency reopened the record before, it actually did include more process about how it should reopen the record, what kind of schedule it ought to proceed by, whether it ought to grant the request at all, those types of things. And it issued an order 18011, defining the scope of what it was going to do going forward. In this case, there was no intervening argument about whether the motion was appropriate, about whether the agency should proceed at all, how it should proceed. There was nothing except suddenly a final order actually granting the offer.
Counsel, what do you mean by closing the record? I think about it in a trial context. All right, that's the end of the evidence, and then there are a bunch of things that need to be done to resolve the case. Are you using the closing of the record in a different sense?
That's essentially the sense in which we're using it. The agency said it would close the record on December 18th, the day that the reply briefs were due. And then it
So
referred.
as I understand it, it never took additional evidence. So in what sense was it reopening the record?
To consider to Exelon's request.
But I think of the record as being the evidence before the adjudicator.
Right.
And reopening the record allows somebody to call an additional witness. How are you using that term?
When I say reopen the record, I think in some ways, in some senses, we do mean it. Well, we're using it to refer to two different points in time, right? One is when the agency reopened the record in October, late October. Then it actually reopened the record. It held another hearing after that, took more witnesses, took more testimony.
At bottom, is this a due process argument, or is your claim that somehow or other they acted ultra virus in proceeding the way they did?
It's both, Your Honor.
Both is predicated on the rule violation or statutory violation, or what?
Again, it's both. Now, our position is that the agency botched virtually every aspect of this. If you wanted to teach administrative law students how not to conduct an administrative adjudication, you would show them this case. When the agency approved the RNSA, it violated its own Rule 130.16 in a way that it recognized would be a violation in the February order. The February order didn't just approve the RNSA, which is exactly what the March order did. And the February order didn't do that because it recognized that would violate the agency's rules. So instead, the commission offered the RNSA to the parties in hopes that they would accept them. Parties didn't accept it. And then the commission went ahead and violated Rule 130.16 anyway. In addition, that was a notice violation, for sure, a due process violation.
Explain to me why the commission violated Rule 130.16?
130.16 says that the commission must accept or reject a non-severable settlement agreement in its entirety. And what the RNSA essentially is a revision of a settlement agreement. So to approve a revision.
I guess the word essentially is there. If the commission at the end of the day says, well, there have been a lot of proposals back and forth, but at the end of the day, and it's relevant to us in our thinking that various people have agreed at various points to various things, but at the end of the day, we are approving this because we made an independent determination that this is in the public interest. I'm not sure that it is acceptance of a settlement. It's really a rejection of a settlement on its exact terms and a consideration of the proceedings as relevant to an independent determination about whether a particular disposition of the matter or approving a particular thing on particular terms would be in the public interest, or at least that seems arguably so.
Your Honor, in a proceeding that the agency said existed solely to consider a particular settlement agreement, particularly in that situation, then to just call it a summary disposition or call it a disposition on the merits, when what the agency effectively does is take some of the terms from the settlement and change them and approve them, would basically invalidate or render Rule 130.16 a nullity. If any time the agency wants to sidestep Rule 130.16 exists for a reason. It's to protect parties who enter into settlement negotiations, to protect the integrity of their deal. This is essentially what OPC and the district's arguments are about more than ours, because we were opposed to that settlement also.
Counsel, you have asked us to vacate the commission's ruling. In your view, what would be the next step if we did that?
You can remand to the agency, and the agency can consider whether, if Exelon wants to, I don't even know if you need to remand. Exelon can go and apply again if it wants to engage in this transaction again. or you could remand and the agency can continue to proceed, but it certainly would invalidate the merger as it stands right now.
Do you want to save your time for
I would like
rebuttal?
to save the remainder of my time. Thank you.
Thank you. Mr. McKay.
May it please the court, I'm James McKay, and I represent the District of Columbia, and I also would like to reserve 2 minutes for rebuttal. The Commission exceeded its authority in ordering Exelon to create and fund an escrow account under the Commission's control as a price for approving the merger. The money belonged to the district under Section 450 of the Home Rule Act and should have been deposited in the general fund or a special fund created by legislation. The action subverted the appropriations process and usurped the authority of the mayor, the council, and Congress. The Commission's actions was ultra-virus, just as its action in Washington Gas Light, where it arrogated to itself the Superior Court's power to impose fines for contempt.
Is it critical to your argument that the funds here were placed in escrow? So that imagine that rather than requiring that Exelon hold these funds in escrow, the order had simply said that as one of the conditions of approval will be that Exelon agrees that it will be responsible for distributing to these purposes as dictated by further orders proceeds in these amounts. Would that be different, or would that be the same in your view?
Well, that would be different. I think that the gravamen of the problem here is that the agency has used its regulatory authority to require a private entity under its control as an exchange for granting it the merger, in this case, to put money in a fund under the agency's control. It's a classic augmentation of appropriations problem.
Just to make sure I understand, if the agency had required that the exact same, that Exelon agree that the exact same amount would be paid out as the agency dictates in future orders in the amounts that would be specified here, but there was just no escrow. It was just that they would trust that Exelon would not go bankrupt and would comply with the order. Are you saying that would mean that would be okay, or are you saying that would not be okay?
That would be perhaps a closer case, but I mean, it depends a lot on the facts.
Well, I assume the facts are as I described them.
Right. I would have to know. I mean, the whole idea, though, is under the scheduled airline offices, under the motor coach case, the agencies there, what they did is they required an entity to put money in a fund, and that is a government fund to be distributed at the government's will. In this case, if you have a direct grant or direct contribution from Exelon to a nonprofit entity, that's fine. That doesn't actually create money received by the government. I think the critical thing is whether or not the money is received by the government. And
strictly speaking, escrow is not receipt. So it must be like you're arguing. Do you agree with that? That literally, well, let's put it this way: title to the escrowed funds remains in Exelon. Do you agree with that?
Oh, yes, technically, but
so ownership remains in.
I didn't hear that first word.
So ownership, in the normal sense of that
title,
term,
yes, but
right.
As a practical effect, PEPCO cannot use that money. It can only the purposes, the recipients, the grant recipients, the amount, the timing, all are within the Commission's direction. It has total control of that money.
And the hypothetical I was giving you, everything is the same except Exelon, PEPCO can continue to use the money. It just is answerable at the end of the day for the same amount and required to distribute to the same entities in the same way.
Well,
and I'm just wondering whether that's the critical feature of it, is everything else is the same and the amount of agency control is exactly the same. It's just that the agency loses the assurance that the funds have already been placed in escrow, and therefore there's some risk that they might disappear or dissipate.
Well, again, that might be a closer case. That is not this case. This case is a blatant, clear violation of 450, or the miscellaneous receipt statute, as the same program, same policy. An agency is basically.
I guess my questions are trying to figure out whether, if the example I gave is okay or might be okay, then what I'm trying to figure out is how significant the differences are between that and this, and therefore how clear it would be that there is actually a violation here.
Well, Your Honor, I mean, there are, on the one extreme, you have a direct grant from Exelon to a nonprofit. That's okay. It doesn't go through the government, even though it might be a condition of the merger. But the other thing is when you put it in the government's control, the government has, the agency has basically received money. It has no program authority to give grants. That's one thing that's very significant. You have to have both appropriations authority and program authority to give a grant. They have neither. The Commission does not have program authority. It had at one point, but the Council took it away. It does not have any program authority by statute to give a grant for anything. And this violates both 450, it violates the basic appropriations rule that an agency has to have both program authority and appropriations authority.
Can I ask you,
it has neither.
Another way of, I guess, cutting at the questions I've been trying to ask is that I think it's undisputed that the district did not reiterate this point on reconsideration. So there's a question about whether the matter is properly in front of us. And I know that you argue, so do you agree that this point was not made on reconsideration by the district?
Well, the precise argument was not made, but the ground was raised. We made it very clear in our motion for reconsideration. Our major substantive problem was that the Commission rejected the NSA, which didn't have any of these problems, and imposed these alternative terms, including these two, and we pointed out in our motion for reconsideration the 4 changes that we criticized in our brief. I also mentioned the fact that the joint applicants had were not under a misunderstanding. In their response to our motions for reconsideration, they identified this as the major issue, that whether the NSA or the RNSA should be the mergers control the merger. In any case, under Washington Gas Light, this goes to very power.
Excuse me.
Yeah.
I'm not sure what answer you gave to Judge McLeese's question. Did you, in your motion for reconsideration, say these funds are illegal?
No, we raised the basic issue. We did not make the specific arguments.
What is the basic issue? Is it we thought the NSA was fine and you shouldn't have tinkered with it? Or how did you preserve the issue you're arguing now?
The issue is basically the Commission's changes to the NSA deprive the district of the bargain, its hard-earned bargain, including, we specifically pointed out, all these funds under the Department of Energy and Environment are now taken away. This is all in a motion of reconsideration, and we cited the dissenting opinion of Commissioner Phillips. They basically, he said, you moved the goalpost. We didn't.
But it's clear, nothing you said put the Commission on express notice that they were violating a provision of the Home Rule Act. Something as important as that.
No, Your Honor.
If you told them that, they would have stepped back and looked at that point, don't you think?
Well, Your Honor, again, this is like the Washington Gas Light case. Exactly, it goes to the very power of the Commission.
Well, that's a jurisdictional case.
Well, we did raise it, but assuming we did not, under the Washington Gas Light, this is a pure question of law of great public interest. It goes to the very power of the Commission. Just like the Commission had no authority, arrogated to itself the Superior Court's authority to fine someone for contempt.
You know, of course, if this is really, as you characterize it, kind of a usurpation of the authority of the legislative branch, the Council can step in.
Well, that's easier said than done, number one. Number two, it's not just the Council, it's the Mayor, it's the Congress. It's basically, this is goes to the very power of the Commission. It usurped the powers of the Mayor, the Council, and Congress. It exceeded its authority, just like it exceeded its authority in Washington Gas Light. And this is a very important question of great public interest, and I think this Court should address it.
One could wonder whether if it would be permissible for the Commission to have done the same thing if they had just not used escrow accounts. One could wonder about the magnitude of any error in its practical significance, and that's part of why I was trying to figure out how far this is from what you think is clearly permissible, what you think is permissible, or what you think is clearly permissible.
Well, the Commission was candid. They said, we don't want the Mayor and the Council to control these funds. There's a possibility, even though there was nothing in the record, that it would happen, that the mayor and the council could exercise its authority to remove the funds from the special funds to the general fund. And for that reason, we're going to control this money. They had no bones about it. They wanted to assert control over this money, and that was a blatant violation of the whole concept of 450 in the Appropriations Act, that an agency, it subverted the whole appropriations process. They asserted an authority they didn't have, both program authority and budget authority. Frankly, it was a very clear error. Nothing in their responsive briefs really address our arguments.
Thank you, Mr.
But thank you very much, and so we would ask you to vacate, but to reverse the decision of the commission and enter the NSA. Thank you very much.
Good morning, Your Honors. I'm Richard Herskovitz on behalf of the D.C. Public Service Commission.
Good morning.
Of the 30 minutes that we have, we are splitting that time equally with intervener Exelon Pepco. I'll just go directly to mention a few matters that I heard the petitioners raise in their oral argument. The first one by OPC, the motion that was filed by the joint applicants, Exelon Pepco, for a decision on the merits, that was notice itself. And what OPC and the other parties failed to add to that is that there was an email issued by commission staff that further explained that it would be considered as a motion under Rule 105.8 of the commission's rules, and parties were entitled to 10 days to respond, and that any other party could file a motion and it would also be treated in the same manner.
It's a little unusual that you're relying on an email by a staffer.
We are not relying on, or the commission is not relying on the email, Your Honor. It was just a clarifying email. The motion itself was clear, as was brought up before. It requested that the commission decide the case on the merits and said no further process was necessary.
No, but the commission's response as to what it's going to do and what the obligations of the parties are in response to the motion was contained in an email sent to the parties by a staffer.
Well, this is
your point is the staffer is speaking for the commission, is that it? Or?
Yes. And the what also was left out of the petitioner's arguments are their responses to the motion. The responses did not ask for any additional process, did not ask for hearings. As a matter of fact, they, meaning the petitioners, agreed that the matter should be decided and decided now. And in our brief, in the commission's brief, we have excerpts from the responses. And the responses clearly show that the parties, several of them would pick out one option or another, but none of them said, let's have a hearing on it. None of them said, we need further process. None of them objected to it.
Do you think they would have been entitled to further process had they clearly requested it?
If there was a reason, I can't speak on behalf of the commission in that regard, but the opportunity was there for them to ask for further process and give a reason for doing so. So it's possible, but I can't speak on behalf of the commission.
Wasn't the proposal of the applicants, and even more so the commission's response, didn't it add new features to the merger?
I'm sorry, I didn't hear.
Didn't the granting of this motion by the commission add new conditions to the merger?
Oh, yes,
Did the petitioners have an opportunity to present evidence that those new conditions were ill-considered?
they had an opportunity to ask to present evidence instead of saying, we prefer that the commission end this matter now and pick option 1 or pick option 3. None of them asked for any further process. So the commission just went ahead and issued an order.
I have a procedural question for you, and to put you at ease, this is a hypothetical.
Okay.
One member of the commission has left, and there is a new member. If we were hypothetically to remand this for further proceedings, could the new member participate in that decision? And if so, what would he have to do in order to participate?
Well, there is some case law on that where a new commissioner can participate in a decision as long as the commissioner reviews the record, reads the transcript. It's not totally prohibitive.
That was my recollection. I think that would be grounds for resignation, wouldn't it, if you had to face reading all the transcript?
In response, also the other matters that were raised, the $25.6 million base rate credit, the repose for rates. The question was asked whether they were in the current rate case. They are in the current rate case that's pending before the commission. So if that is used as the basis for any potential remand, it just doesn't make sense in light of the fact that these issues are now before the commission.
Well, I think your opponent's argument is that the NSA had terms with respect to that were better, and that the commission really didn't adequately explain why it was, rather than accepting those, kicking the can down the road to the more uncertain outcomes of the subsequent rate-making procedures. That's among their various objections. That seems to me to be one of them. Do you think the commission adequately explained why it was that it was taking some, in a variety of respects, more firmly rooted and settled protections, and instead kind of transforming them into, we'll see how it all pans out in later rate making?
I think I missed the first
yes, so
part
the question is, one of your opponent's arguments is kicking the can down the road to future rate making was a bad idea. The NSA created some fixed benefits that are lost now because who knows how it's going to spin out in future rate making. What's your response to that point, and also the extent to which the commission adequately explained its thinking on that point?
Well, the commission could have just postponed it until the rate case. There was no requirement that the commission affirmatively approve that in the NSA, so that
I'm not quite sure. If your opponents are arguing the commission was being asked to do that, that was a better resolution of this topic. Are you saying even if it was better, the commission could say, well, we don't have to do things that are better, so it's enough for us to say
yes,
what we have is pretty good and we don't have to do what's better?
I'm sure there are a lot of things that are better than what they did, but the issue is whether what they did is in the public interest.
So this is a very abstract question about how the commission understands its obligations under the public interest standard, and it relates to some arguments the district made that we haven't yet explored at argument. So is your point that if a party comes in with a plan and the commission ends up thinking, well, if the option is nothing or this plan will advance the public interest to a degree, and an opponent comes in and says, well, maybe so, but here's an aspect of the plan that could easily be fixed that is in its, that by itself isn't good. So commission, make them fix it, make the plan better serve the public interest. Are you saying the commission can say, might be easily fixable, might not be? That's not really our responsibility. All we need to do is to determine that considered as a whole and relative to doing nothing, this makes the world, slightly better place.
No, I'm not going quite that far, Your
Where are you
Honor.
going? Where are you going short of that? Because your answer to me seemed to be basically akin to that.
The proposals that may be better may have some, may not have sufficient support in the record for them.
Well, no, and certainly the commission could say, could give a reason and could say, well, the argument is that it's better, but I don't think it really is better, and here's why it's not better, and therefore that's why we're not doing it, and here's why the plan as a whole is in the public interest. But your opponents argue that that was the commission's responsibility and it didn't adequately explain its reasoning, and in fact it reached the wrong conclusion about whether the approach it took on that topic was better. And I'm just interested in your response about both why this approach is better and also whether the commission adequately explained its reasoning on that point.
I thought implicit in your argument was, at least with regard to one of these issues, which is the so-called negative allocation of rates, who's paying, as between residential customers and commercial customers. The commission is in effect saying, look, we have had this issue under consideration for a long time in a series of rate cases. We're still wrestling with it. It shouldn't be resolved in the context of this one proceeding when it's kind of an ongoing issue that we have been considering and will continue to consider in the next rate case or two. I thought it was more the idea that, not just that it's the better way to go, but this, if we accept the settlement agreement, it in effect prejudges an issue that we have been giving a lot of attention to and want to continue to give attention to. Is that something like what they're saying or not?
Yes, it is, Your Honor. It's just not a matter of whether something on its face is better. There are other considerations to be.
I mean, they also said we have this whole issue of, well, what grids is it? We have that under consideration too. Although it doesn't seem to be as pressing an issue to them as overcoming this negative imbalance in who's paying what.
Yes, everything has to be taken into consideration as a whole. I think you were speaking to microgrids.
Yeah.
Yes, and there is an active docket at the commission that's examining that.
Could I ask you another question with regard to Mr. McKay's point about the commission's deciding it was going to require PEPCO to set up these funds under the complete control of the commission? I mean, the city has a lot of agencies. Shouldn't we be concerned that others will follow the example of the PSC and start telling the people that they regulate, we would like you, indeed we expect you and we require you to set up some kind of escrow funds. We'd like to have those funds secured for purposes that we will determine in the future. When the time comes for us to do it. And so you have kind of a whole bunch of these independent funds. They're not in the commission, they're not in the agency's possession, but they're sort of not really in the possession of the regulatees. Wow. And it's, let 100 of these funds flourish. Don't we get pretty close to telling the council that, well, that may be your function generally to specify funds where where the monies go that are collected from people regulated. But it's a problem. I mean, you have a statute which basically says it's the council's job to determine how the taxpayers' money is allocated and is spent.
Yes, and under the law that was cited by district government, the key is money that is received belongs to district government. And there's no receipt of the money.
But you would agree that at least some of the federal cases and Comptroller General opinions reflect the idea that even in the absence of formal surrender to the government, the limitation here can be transgressed by arrangements that end up being functionally equivalent to or essentially de facto control by the government in other, as long as the other circumstances are problematic enough.
But here, there's the cases that were cited are like constructive receipt, I think you're speaking to. The money is owed to the agency.
Right, I was just wondering whether
whether
your position was formal receipt is always required, or whether you agree that if other circumstances are problematic enough, lack of formal receipt may not be fatal.
Well, I think that the constructive receipt argument has some merit.
Okay, can I ask you, just, you agree that if title to the escrow account had been required to be placed in the commission, that would have been indisputably a violation of the relevant statute?
If
PEPCO had been required to transfer the funds here, not to an escrow account as to which it holds title, but instead to an escrow account as to which the PSC held title, that would be a facial violation of the statute?
I don't know if it would be on its face a violation, but that would be a very
what would be the argument?
Call.
What would be the argument that it isn't? Wouldn't those funds have indisputably been received by the government if title to them was placed in the Public Service Commission?
Yeah, the commission would be using those funds for the benefit of ratepayers, and yeah, it is close to the.
Well, let me ask you: if you think that's close, then what's the real world difference between that and what happened here?
Well,
who cares who has actual title over the escrowed funds? What's the practical significance to any interest that or what's the real world practical significance of who holds title to the escrowed funds? It might have a formal difference, and maybe that matters, but I'm just trying to figure out whether there's any practical difference.
Oh, the practical difference would be that if the agency held the funds, that would be for the use of the agency, in my opinion. If it's under escrow, it would be.
Well, I'm assuming that in both instances the funds are in escrow, and it's just a question of who holds the title to the escrow account.
As to who owns it, I don't think it makes a difference if they're both under escrow.
Thank you, Mr. Herskovitz. Your time has expired.
May it please the court. My name is David Debruin, counsel for PEPCO, Exelon, and the joint applicants below. I'd like to address some of the specific issues that the court has raised, but I think it is also helpful to step back for a moment and to consider the overall context, that the commission approved this merger as revised, and as the merger had been significantly revised to more than double the amount of the savings from the merger that would be used to provide rate credits for customers, to forgiveness of debt of customer arrearages, investments in grid modernization, investments of energy and conservation, only after finding that the merger, as revised to include all of those terms, was in the public interest, and in a process in which the commission had had repeated rounds of evidence briefing by all of these parties, 14 days of evidentiary hearings, 6 days of community hearings, and extensive orders in which the commission meticulously evaluated every provision of the merger, rejected it when it found the merger inadequate, reviewed revised terms that the parties put forward, still found those terms to be deficient in limited respects, exercised its authority to propose alternative terms, and when the parties collectively did not agree to those terms, then entertained a clear motion from the joint applicants to have the merger approved under those terms without further proceedings. And I submit to you that that totality of the record, which spanned over 2 years with extensive proceedings, is precisely the way an administrative agency should act, working incrementally, reviewing, requiring changes, evaluating changes, essentially saying you've come far but not gone far enough, and the order should be affirmed. I would also note in my opening remarks that, again, this merger closed more than a year ago on the terms the commission approved. None of the parties here sought a stay.
Let me ask you about the point you just made. In your brief, you referred to this as an iterative process. You just referred to it now as an incremental process. What is the difference between that and making it up as you go along, with which your opponents seem to think is a violation of due process?
Your Honor, this could not be the furthest thing from making it up as you go along, and simply saying that does not make it to be so. The commission operated in a manner consistent with its rules, consistent with this court's precedents. Unquestionably, the commission entertained the merger application by the joint applicants, had extensive hearings, briefings on that proposal, issued a decision in which it found the merger not to be in the public interest, and identified reasons why it was not in the public interest. The parties, again, not all of the parties, but many of the principal parties, then met and discussed and ultimately proposed changes to the commission in the NSA, the non-unanimous settlement agreement. The commission orderly reopened its record to consider that proposal. It still had an obligation under its rules, 130.11, to evaluate that proposal on the merits to ensure that it is in the public interest. In other words, even a full settlement, if you look at the text of 130.11, does not mean the commission steps back and says, we've got a settlement, all done. No, even then, the commission has a duty to evaluate that settlement, and that's exactly what it did. It opened the record. It had 3 more days of evidentiary hearings, 2 more days of community hearings, more briefing, more evidence. The record opened for that process, and it evaluated the proposal, and still the commission was not satisfied. It identified discrete issues that it was concerned with. It explained those at length. And under, again, commission rules, this is not making it up, this is not doing it on the fly. Under Rule 130.17b, one of the things the commission can do is, quote, propose alternative terms. And that is exactly what the commission, by a 2-to-1 vote, in a very extensive opinion written by Commissioner Fort, explained. The NSA had come quite far from the original proposal. It had more than doubled the amount of the savings that would be dedicated to the District of Columbia, to ratepayers, to other purposes.
Can I ask you about that particular aspect of it? Because your opponents argue that in the original order rejecting the application, with respect to, I guess, the customer investment fund, the CIF, and the discussion of synergy and the 30-some-odd million dollars approximately allocated at that point, that the commission identified some pretty fundamental concerns. We don't really understand, I'm paraphrasing, but as they suggest, I think, that the commission was saying, we don't really understand the value of this transaction to Exelon and its shareholders. We don't understand and have some reservations about the calculation that generated the approximately $30 million figure. It may not be fair to the district. We don't understand how that works across other jurisdictions. So we have a bunch of concerns, is what the commission originally said. And your opponents argue that although the number there was more than double to 72 million or some number like that, that really doesn't provide an answer to the concerns, or at least all of the concerns that the commission had. It doesn't tell you whether that's either that number might be equally arbitrary or senseless, and in fact, it gives you reason to doubt the accuracy of the original number. And there were concerns about synergy savings and passing them through, and that really none of those ever got specifically addressed by the Commission when it ultimately approved things. And so what's your response to that concern?
Again, I think that the record belies that contention. If you look, again, you have the original Commission order, which you've referenced, which does identify concerns. The NSA then significantly revises and changes the proposed terms of the merger, and the Commission evaluates that in the February order 18109 at great length, and in particular the decision of Commissioner Fort, which is essentially the swing vote. Commissioner Phillips describes at length why he believes that the revised terms in the NSA do now meet the public interest standard. Commissioner Fort discusses at great length both why there are still identified specific shortfalls, but why, if those specific issues were addressed, the merger in its totality would be in the public interest.
So far, at least, your answer seems to be in the nature of nobody really, the Commission never explained why those aren't still problems, but rather, in your view, the Commission ended up concluding in the general language in the final order saying, well, there may be additional problems, but they're outweighed by the benefits of the merger. Is that your the thrust of your answer, or do you also think there were adequate explanations?
If you look at the entire context of the Commission's orders, both the February order where it evaluated the NSA in great detail, then the March order 18148, where it ultimately approves the merger under the revised terms of the NSA and addresses the public interest finding in multiple paragraphs. It also has detailed findings of fact which go through each of the 7 factors. The Commission explains in great detail exactly why it finds this merger as revised.
But where does it explain specifically whether this is still a concern, notwithstanding the $72 million, or if not, why not? Is there any place where any commissioner or the Commission as a whole delves into that topic and provides a specific explanation about whether that still is a concern, what the magnitude of that concern is, why, if it's still a concern, it's outweighed by the other benefits? Where would I find that?
I think the orders as a whole do that, but I guess
if you think
I can't cite a specific paragraph offhand, but what is, I think, more critical is the Commission had a merger proposal, and it essentially found that proposal to be deficient. It said, we're not going to tell you exactly what kind of proposal to make, and it set that aside. Then a new proposal was set forward, which is essentially the terms of the NSA. And the Commission evaluated that essentially as a fresh proposal. It reopened the record, it had more hearings, more evidence, and it then evaluated whether that proposal satisfied the public interest. And it did so at great length, going literally term by term, addressing every objection that was made by any party.
But Mr. Debruin, one of the few controls we have over administrative agencies is the obligation for them to fully and clearly explain why they think this is in the public interest. The problem is what you're arguing requires too much work. You got to read, you got to piece together, you got to discount this, you got to add that. And I'm wondering if that satisfies the Commission's obligation to fully and clearly explain its reasoning.
Absolutely. If you look to the March order, paragraph 1, paragraph 39, paragraph 46, and the findings of fact, all of those in particular identify precisely why the merger as revised is in the public interest, and significantly.
So let's assume that we wipe out everything else the Commission has written and focused only on what you've just identified. Would that be sufficient to fulfill the Commission's obligation?
Well, I think it would be. This Court has said that the Commission must identify the principal reasons for its actions, and it must address the principal objections that are made. It doesn't have to address every conceivable argument that might have been made, even if it wasn't made, and it can focus on those issues that are most important. The paragraphs identified, along with the findings of fact, and again on rehearing, paragraphs 90 to 92 readdress this, summarize why the merger as revised is in the public interest, and why, if the merger failed, which it was essentially at risk of doing because there had not been unanimous agreement to the revised terms in the February order, that the customers in the District of Columbia would lose the benefits that the merger was providing. Again, there are synergies from a merger. They were estimated to be approximately $90 million. The joint applicants had agreed to funnel approximately $70 million of those savings to district customers, to grid modernization, to energy efficiency. All of that would have been lost, and that is exactly what the Commission explains.
The Commission's original order was, we can't really figure out, we're not very confident about understanding the synergy, the actual synergy savings that there would be, and therefore we're not really sure to what amount, in what amount it would be appropriate to pass those through.
But that's a judgment the Commission makes.
Well, I understand. Now, let me just finish the question. And so I understand your point, perhaps, that if the Commission had said in the final order, in the original order we had concerns about the amount of synergy savings, the calculation of $36 million, and how the whole structure of this transaction, the numbers now increased to $72 million, and although we're still unsure about aspects of this, we think that that uncertainty doesn't undermine the overall extent to which this merger is in the public interest, and we don't really think that there's much more we can usefully do in trying to sort any of that out. So on balance, we're going to say that's a shortcoming, but it's not reasonably fixable and it's outweighed. Then that would be one thing. But you would agree, at least as you stand here, you can't point to any point of, any part of any decision by any of the commissioners or the Commission as a whole where somebody actually spoke about these set of problems at that level of detail.
Well, I think what you're identifying is there is a certain amount of uncertainty that is inherent in any merger. If you have two entities that combine, there will be savings from the synergies of that combination. The precise dollar amount of that is not something that can be known at the time before the merger is even closed. And so one of the difficulties the Commission, and again, the Commission here was only one of multiple states that was evaluating this merger, as did Maryland, as did Delaware, as did New Jersey. All of this has now closed under the approval of all of those states. One of the things the Commission recognized is it was difficult to identify what was likely to be the amount of savings, and then what is the proper way to allocate that. And the Commission evaluated that, found the initial proposal to be deficient. The parties came back, the joint applicants significantly raised amounts, addressed concerns. Commissioner Fort, in her opinion, specifically stated, and I don't have the paragraph, that the NSA had, in fact, addressed many of the concerns that the Commission had identified in its original order. That the Commission did not say, here's the terms that we will approve, but it had, in fact, identified and essentially provided a roadmap, and I believe that is the word used in the rehearing decision, of concerns the Commission had, and the NSA had, in fact, gone very far in addressing those concerns, but yet still the Commission did not step back. It was still concerned about specific issues, and as Judge Farrell noted, one of them is, although now a significant amount of additional money had been allocated for customer rate relief, all of that money under the NSA had been allocated to residential customers. And the Commission raised an issue, again, in the public interest, is that the proper allocation of that amount of money? And rather than...
No, on that aspect of what the Commission did, I think it did explain its thinking. I guess there are other aspects where the Commission's, leaving aside what the Commission substantively could reasonably do, the explanations were a lot less detailed, it seems.
Well, it does sound like, in part, the Commissioner simply decided we really can't tell at this point with any accuracy, what the savings are going to be from this merger. But we're going to require PEPCO, I think they said somewhere, to, on an ongoing basis, account for what those synergy savings are and report them to us, and we'll look at them in each successive rate proceeding. Is there something like that in the ruling?
That is correct. And I mean, there were many aspects. Just to take another example, one of the things that the Commission was concerned about was the extent, and this is in the original order, the extent to which there would continue to be a strong presence in the District of Columbia from PEPCO following the merger. And so one of the things that was addressed in the NSA was commitments by Exelon to increase its presence in the district, to have particular offices located in the district, particular officers present in the district, particular officials of PEPCO on Exelon's different boards and groups. So all of those changes in the NSA directly went to address concerns that had been identified in the original order. And Commissioner Ford, I believe in particular, in her opinion in the February decision, explained why, given those and other changes, the NSA did, in fact, address concerns the Commission had had and did bring the merger into the public interest, although then again, she wasn't satisfied and felt there were at least 4 particular areas where the merger proposal did not yet go far enough. And so in terms of protecting the public interest, making sure that this merger would not be approved until the Commission was completely satisfied, I don't think you can have a stronger record of this. And I think as you look at the changes, you can see the Commission accepting those changes because they addressed concerns such as commitment to the district that had been identified.
Thank you.
I just one very technical question, which is, I know that the Commission in its final orders adopted by reference other things that the Commission had done. Do you understand that to have included Commissioner Ford's separate opinion, to have been adopted? I just don't recall right now
Yes,
whether it was or
of course,
wasn't.
absolutely.
I just don't recall.
And that is explained in the final
Yeah, I just
order.
couldn't recall.
Somehow my time has already run up. If I could have just 1 minute, I would like to address just the district's argument, which the court had several questions about, just very briefly. First of all, it's clearly waived. It was not raised. They did object to the change, but they did not raise this home rule issue. This does not go to the jurisdiction of the Commission to approve or not approve the merger. It doesn't fall within Washington Gas, so it's waived. But secondly, on the merits, this is clearly not, these funds have not been received by the Commission. These funds were not owed to the district. They're not owed to the Commission. This is money that was set aside for particular purposes, grid modernization, energy efficiency, and essentially they were put in escrow simply as a means of ensuring that the money, the commitment that was made would be present.
So if the taxi cab commission says to all the taxi cab firms and taxi cab owners in the city, we're requiring you to set up an escrow fund with a trustee to be named by us. You're all to make contributions into that fund periodically so that we can beautify taxis in the district, which are very unsightly. We, the Taxi Cab Commission, will determine how those funds are to be spent. That's okay?
No, the critical issue is that money owed to the agency? So, for instance, and I think this goes to one of...
No, it's going to be used for beautifying taxi cabs.
Well, it's not, the issue is not the purpose. The issue is it owed? So, for instance, and I think a question Judge McLeese asked, if the FCC sells spectrum and money is generated, that money cannot be received and then held by the FCC for, quote, communications purposes. That is money owed to the United States government by reason of the sale of spectrum, and that money must be deposited in the United States Treasury, and it cannot be spent unless it is reallocated by Congress. That's the purpose of this so-called Miscellaneous Receipts Act. The key is, was the money owed to the government, to an agency? So if, for instance, the taxi cab, if I can just finish with the hypothetical, if the taxi cabs, by reason of a license or a fine for misconduct of some kind, owed money to the Taxi Cab Commission, either a license fee or as a payment of a penalty, whatever it is, that money is owed. And the Taxi Commission said, well, instead of you paying it to us, and clearly if that money was paid, I will say clearly yes, the statute applies. And if the Taxi Cab Commission said, instead of paying it to us, we're going to have you pay it to X, Y, or Z, put it into an escrow, all of that comes within the statute, absolutely. But the key is because that is money that is owed to the government.
Thank you,
this
Mr.
money
Debruin.
here was not. Sorry, thank you.
Mr. Strauss, 2 minutes.
Very well, thank you, Your Honor. First of all, a staff email is not commission notice of anything in any case, let alone in a case of this magnitude. We responded to the Commission Order 18109 in the way the Commission had requested us to. We were asked if we supported the revised terms of the settlement. We said we did not. And the PSC never said we could use this process to file for unilateral relief. It only talked about joint relief. Now, we thought reasonably in this circumstance that the proper response was to tell the Commission that we did not agree to the revised terms, and that Exelon's filing was procedurally out of bounds. And we did that, and we explained that in our March 11th order. As to what was actually done, the Commission said in its orders 18148 and then again in 18243 that it was restoring the incremental offset provision. That was the provision that would limit recovery after the period of rate repose had expired. It was a very important way to limit rate shock, but the Commission botched it. As we explained in our reply brief at footnote 15, what they adopted was just an additional $1 million base credit possibility. That wasn't the same thing as a limitation on recovery after the period expired. The Commission also did away with the period of repose, and we don't understand the basis for that at all. At a minimum, we'd like a remand to at least have the opportunity to present our arguments about why those provisions were incorrectly adjusted, if you want to use that word, by the Commission, or simply dropped out of the process. I want to point out more broadly, the Commission's action in this proceedings undermine the integrity of its own processes. It's not just this case. As Commissioner Phillips pointed out, parties will be wary of settling cases if the Commission can rewrite their deals and then without proper process simply adopt the terms as a merits-based resolution because one of the settling parties happens to prefer them. It would be difficult to settle under those circumstances. Think about it. You win a case, it's on reconsideration. The other party offers you settlement terms, and you say, okay, those sound pretty good if we can get that approved. The Commission considers them and rejects them in part and says, no, that's not an appropriate settlement. But we have these other terms. If you like those, you can have those. And you say, thank you very much, but those aren't the terms I agreed to. I don't want to settle. I'll go along with the case. The Commission turns around and really without appropriate notice announces, actually, we're going to consider that as a merits-based resolution, and we grant summary judgment.
Mr. Strauss, we have your point.
Very well. Thank you, Your Honor.
Mr. Arkush?
Thank you, Your Honors. Exelon's point on the SIF boils down to some uncertainty remained, and the Commission never did really resolve the uncertainty about the value of the SIF or its basis. That is not adequate. That was the central purported benefit of this deal, and we have no reason to think it was anything other than just made up out of whole cloth. And in fact, in the current rate proceeding, Exelon is asking for a rate increase that would claw back more than the entire amount of the SIF.
How would we ever be certain about what the amount's going to be until we work through it?
Some residual uncertainty is fine, but in this case, there was total and complete uncertainty. Before August, we had two completely conflicting assertions about how the SIF was derived. One was that it was based on meter counts, which was a method that was discriminatory toward the district. PEPCO didn't even manage to submit an accurate count of its own meters to the Commission. There were a number of flaws with that approach. The other was that it was actually just based on a number from New Jersey settlement, plucked out of thin air as far as the district is concerned. That number is totally arbitrary in the context of what is good for the district. Beyond that, there was no evidence ever introduced on the SIF. Right? So Exelon now says there was some residual uncertainty. Well, guess why? When they upped the number to $72 million, they never introduced a shred of evidence to support the $72 million figure. We have no basis for it whatsoever. So yes, there will be some uncertainty remaining about the precise nature of synergy savings going forward. Here, there was total uncertainty, and the fault lies with Exelon. And what this shows is that the agency didn't proceed incrementally and iteratively and fix this deal as it went. It just dropped the ball. It seemed to somehow just not even notice that these concerns never got addressed. Now, again, Exelon says that Fort discussed extensively all the concerns from August. That is absolutely not the case. Unfortunately, the court shouldn't have to do this. You shouldn't have to read all of these orders so carefully to try to figure out what happened. That goes to our clarity point. But what Fort actually does is she addresses the 4 new issues that the PSC found with the NSA, and she goes back and addresses 5 of the issues from the August order.
Thank you, Mr. Arkush. Mr. McKay?
I have 2 quick points, Your Honor. First, the funds belonged to the district, whether or not they were owed. The motor coach case, the scheduled airlines, they didn't, there was no debt. They were required contributions, which the agency had no power to make. The Commission, second, the title to the escrow account is not determinative. The point is that the Commission had total control of that money. was absolutely total. This violated Section 450. The second point is that the commission did not fully and clearly explain its action approving the RNSA. It did not go through the 7-factor test it has established. It did not meet this burden simply by incorporating by reference to prior orders.
The addendum B or whatever to the final order went through all 7 factors.
Those were the community responses. They weren't necessarily the commission's views. I looked, that is the factors. The commission relied in its order. It had a footnote saying we basically incorporate by reference our prior order, 18109, 17979. And those orders rejected the merger, and therefore, speaking of a full and fair explanation, you don't get there by incorporating by reference orders that rejected the merger. Therefore, at least this court should remand for a full and clear explanation. Unless this court has any questions, thank you very much.
Thank you, Mr. McKay. We thank all counsel for their arguments. The case will be submitted. In a moment, the court is going to take a brief recess to reconstitute the court. We will hear the Hollis case next, and we'll ask counsel to be in place when the court returns. Thank you.